Welcome to the new lecture that pertains to the case study relating to the interpretation of Section 3D explanation of Indian Patent Act. Recently, the Delhi High Court, in the case between Ischemic LLC and the Controller of Patents, had an opportunity to consider whether the applicant for patent incorporate additional material in the patent specification or even during the hearings, during the prosecution of the patent application, to introduce new data or material which was not part of the original complete specification filed at the time of making the application. This is a very interesting case, and I would say that in this judgment, the Honorable Justice Miss Pratibha Singh had only continued and followed the earlier decisions given by the Delhi High Court in the number 1 AstraZeneca case, number 2 Oyster Point Pharma case. Okay, these cases are also earlier judgments of the Delhi High Court on the point. Now, this Section 3 is peculiar to Indian Patent Act. Section 3 lists out what are not patentable invention. In other words, Section 3 incorporates detailed criteria for determining the statutory subject matter. We all know that patent is granted for an invention having commercial application. The criteria for patentability is novelty, utility, non-obviousness or inventive step, and 4, most importantly, statutory subject matter. Now, the first 3 criteria, namely novelty, utility, non-obviousness, are same for the entire world. It is only the statutory subject matter differ from country to country. Now, Section 3D explanation, this was incorporated during the very recent amendments to the Patent Act actually. Section 3D explanation, let me very quickly read that for you. Section 3D, a mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance, or mere discovery of any new property or any new use for a known substance, mere use of a known process, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. The explanation further provides, for the purposes of this clause, salt, esters, ethers, polymorphs, metabolites, pure form, particle size, isomer, mixtures of isomer, complexes, combination and other derivatives of a known substance shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. Now, material to establish efficacy, what is the matter in dispute in the present case? Okay, now I just read this to you, and I want you to remember that the Section 3D explanation was incorporated in the Indian Patent Act essentially to prevent evergreening of a patent. These pharma companies are very good in managing what is known as the product life cycle of a molecule. a molecule is introduced, a better version of the same molecule is again patented, derivatives and combinations of the same molecule become subject matters of new patent applications, and thus normally a patent monopoly would have expired after 20 years from the date of the first application. By claiming additional patents for the new innovations or incremental improvements to the basic molecule, the patent owner continues to get new patent monopolies which will outlast the period of monopoly that was granted by the original patent. This way, the company can ensure that for a period of about 30 to 40 years from the date in which the molecule received regulatory approval, they would have an effective monopoly. This is their game. All right. Now, we must appreciate that after Corona, there had been a lot of path-breaking changes of attitude. The government of India thought that COVID medicines should be off the patent monopoly. COVID was a new disease. At that time, when it grappled the humanity, there was no known medicine to treat COVID. And after many countries imposed curfew, lockdown, and a lot of things, many countries came up with the vaccines, and many of them were subject matter of patent. And many antiretrovirals or combinations of these antiretrovirals were tried to treat COVID, and some of it became subject matter of patent. And Government of India, flew kites in the international community to find whether these inventions that will have an important bearing in treating the COVID patents can be described off patent. WTO provides for national emergency exceptions during the time of pandemic. There is a pharma patent. If it will have a very important bearing in dealing with the national emergency caused by a pandemic, the state can declare that for a temporary or a permanent period, the patent will become non-enforceable. It will be some kind of the nationalization of the patent, and in which case the central government will probably provide an appropriate compensation to the patentee for the loss of market and profits because of the declaration that the patent will not be enforced henceforth. This is a very interesting situation. But you know that most of the countries did not particularly like it. China accepted it and said that they will apply it only for vaccines. It's a very interesting situation. It is in this social and the global milieu we have to consider the recent Delhi High Court judgment. The applicant in this case filed a patent application for a new isomer of a known substance. And this substance was to have an important application in treating the patients of ischemia. Ischemia, is a disease that is caused because of sudden stopping of blood supply to different parts of the body. The blood supply gets stopped due to various abnormalities, and then the medicines or due to natural causes the blood start flowing again. When it starts flowing again, that can also cause harm and inconvenience and illness to the patient. And this molecule was supposed to take care of these problems. When the ischemic patients' blood flow is restored, they may probably suffer some disabilities, and the patented invention is expected to take care of it actually. See, this is the basic facts of the case. I told you about the earlier two cases. One is AstraZeneca case and the other is the Oyster Point Pharma case. These two cases. Please remember that most of the inventions today have global market in mind. And the patent often originates, most of these research products, originate either in Europe or in North America. So they make a first application there. And they will probably take, in most cases, the PCT route nowadays. That is Patent Cooperation Treaty route. After first application, within 1 year, they file the PCT application and within 3 years of the date of publication of the first patent, they enter the national pace of different countries. This is how it is done. And for you to take the advantage of the convention patent application route, the subsequent applications in other territories have to be an ad verbatim copy of the first application. That is the basic rule. Now, in India, you have the Section 3D requirement which says that unless there is a significant improvement with regard to the efficacy, derivatives of a known substance, different forms of a known substance are not patentable invention because the Section 3D says it's just the same molecule and there is no novelty. Fine. So the problem is, since all the applications follow the first application and since Section 3D is peculiar to India, all the applicants may not incorporate information on efficacy. Please also remember that earlier in the Novartis case, the Honorable Supreme Court of India held that even 30% increase in the bioavailability of the beta-crystalline form of imatinib mesylate will not constitute a significant improvement relating to efficacy. The Supreme Court took a view that efficacy as known to a pharma person is the ability of a molecule to cure a disease or disability. Any other thing will not be considered as efficacy. So therefore in Novartis case, the patent was denied. This made the rest of the world to believe that India unreasonably refuses inventions in pharma industry, essentially to give an unjustified benefit to generic drug companies. Today you know that India has become the global headquarters of the generic industry, and now very simple. That is, the original specification does not contain any information relating to efficacy. Now, after the patent is granted or when the patent is being considered, the company applies for regulatory permission. For getting regulatory permission, they conduct clinical trials. Now, in the clinical trials, they generate a lot of information. Now, whether they can give the information that they generated during clinical trial, during the hearing of the patent office, in order for them to establish efficacy within the meaning of Section 3D. Earlier two cases, AstraZeneca case, as well as in the Oyster Point Pharma patent application, the Delhi High Court itself has held here, whatever information you have at the time of the prosecution, during hearings, you can give it to establish that there is efficacy. Okay, that is the basic law. Now, the Delhi High Court exactly confirms the earlier trend. Okay, in these two cases that, you can even make an amendment to the patent specification if you wish. Now, amendment of patent is considered in section 57 to 59 of the Patent Act. Now, an amendment is permissible so long as the amendment is a disclaimer, correction, or explanation. Disclaimer, correction, or explanation. The clinical trial data will obviously fall under the category of explanation as contemplated under section 57 of the Patent Act. And in any case, but it would mean that the applicant is going to incorporate new material which was not there at the time of filing the application. This is prohibited by section 57. Plus it says that a scope of the claim cannot be substantially improved by resorting to amendment. Okay. Now the question is very simple. Number one, the data which is generated after the lodging of the application, can it be made part of the patent specification? In fact, there should not be a difficulty so long as the data can come under the category of explanation. You make a statement that there is an increased efficacy, or most of the countries do not have the efficacy requirement. The patent specification need not necessarily talk about the existence of efficacy because rest of the world don't bother so much about efficacy so long as there is novelty, utility and non-obviousness. The statutory subject matter 3D explanation is peculiar to India. Now the Honorable Delhi High Court, speaking through Justice Pratibha Singh, had said, look here, even if new information is available to the applicant, okay, that can become part of the patent specification simply because this is more an explanation to the information which is already available in the patent specification. The court also considered the distinction between in vivos and in vitro. Okay, in vivos, occurs within the body. In vitro takes outside the body. Now, when you talk about patenting diagnostic methods, etc., the general rule is inventions relating to in vitro treatment, that is when you treat something outside the body, they can be patentable. But if it is in vivo, it will not be patentable, and there is a very, what I call, passing discussion on this aspect also. And furthermore, what is important is that India has been perceived to be a patentee unfriendly country. And because India is the headquarters of the global generic industry, they all think that the Indian system discourages patents by research companies essentially to prevent the evergreening of the patent, and this is a perception actually. Now I find the Indian judiciary is trying hard to shed this image. Recently we talked about Madras High Court judgment which condoned applicants' failure to take a foreign filing permission and directed the controller of patent to grant such permission because, there has been a substantial compliance of the requirements contemplated under section 39, 40, etc. This judgment confirms the trend. I think it's a very good judgment because, please remember, very quickly I will say, a patent is a quid pro quo. What is the quid pro quo? In consideration of the applicant disclosing to the general public the best manner of performing the invention, the state gives a monopoly. So, disclosure is very important. Now, disclosure the applicant makes as it was known to him at the time of filing the application. Now, after filing the application, after starting to work the invention, the applicant will come to know a better mode than the best mode requirement he has originally disclosed in the patent specification. So he is coming up with a better mode, and the better mode is can also be informed to the general public. After all, a patent is going to be valid for 20 years. Now, I get the patent during 2020, I get the patent in 2023, I get the regulatory approval in 2024, and I commence manufacturing in 2025. Now, by 2030, I would have had lots more information than what I had at the time of filing the application in 2020. In my opinion, by allowing the patentee to incorporate such information facilitates better disclosure. And furthermore, this Section 3E, Section 3D explanation is peculiar to India, and the applicant has to file the same application in all the jurisdiction if he has to claim the priority as per convention application route. So therefore, I think it is a very nice judgment, and I agree with that wholeheartedly, and it does a lot to improve the image of the Indian system when it comes to getting more patentee friendly. That much about it. Ladies and gentlemen, you know that these lectures are given as part of my patent agent examination series actually. Government of India is regularly holding patent agent qualifying examination. The next examination is scheduled to be held during 24th early part, and in order to enable the students to prepare better for the exams, we have put up 5 courses on patent law and other aspects of intellectual property law, and I am giving the links for enrollment to these courses, and I hope you will find it useful. Share and subscribe this podcast. Thank you.